We are, however, very fortunate to have with us Chartered Surveyor, Managing Director of Raymond and Pale Limited, immediate past President of the Joint Consultative Council for the Construction Industry. His name is Afra Raymond, no stranger. Afra, very good morning to you. How are you, sir?
I'm very good, Rennie. With that introduction, I feel like $1 million.
But you are always working your $1 million, both in your energy and your actual resources, to bring answers for the people of Trinidad and Tobago. So the $1 million title is still most appropriate. Afra, let's talk about Invaders Bay. Let's talk about the appeal court hearing. Let's talk about what happened October 28th. The appeal court delivered its majority ruling upholding the decision of Justice Frank C. Passard on July 14, 2014, to order publication under the Freedom of Information Act of the legal opinions on which the ministry had been relying for some of its decisions. The Joint Consultative Council for the Construction Industry had won its case at both the High Court and the Appeal Court. You called for the immediate publication of the requested information on November 21st. The state obtained leave with the JCC's consent to appeal this matter at the Privy Council. You say the government appeal is a direct contradiction of their position while they were in opposition. For background and context, Afra Raymond, let us start with a synopsis of what the Invaders Bay case is all about.
Well, what we have here, Rennie, thank you for having me on the show this morning.
Always a
Thanks
pleasure.
to the radio station, and good morning to all your listeners. What I want to say is that Invaders Bay is a 70-acre parcel of land behind the movie town, which is south of movie town on the Foreshore Highway, the Audrey Jeffers Highway. It's reclaimed land, and the development of that land is quite important, not just for the size of it at 70 acres, but because of the implications of the development. It's very ready for development in that it's relatively flat. It's got ready access to water and lights, ready access to the country's road network, and it's a coastal piece of land, so there's a view of the sea right from there. But what's interesting about it is not merely the size at 70 acres, but because of where it is, which I just outlined, there are tremendous spin-offs, collateral benefits that could accrue from the development of that land. Therefore, we need to be sure, A, that the development takes place in a proper manner, in accordance with good practice and accordance with the law, and B, that whatever development takes place there has a maximum positive economic and social impact.
You mentioned collateral. There's also the collateral question of land erosion, which is another side of this whole prospect.
You see, part of the thing with that land, Rennie, is that the development of that land will actually have an impact environmentally in terms of the taking away of some of the mangroves and the other creatures that have grown and lived there since the land was reclaimed roughly 20 years ago. And it will also have an impact in terms of drainage and other collateral impacts on the city. So it's a very important issue, the development of Invaders Bay.
Yes.
What happened at the end of August 2011 is that the Minister of Planning, which at the time the minister was Dr. Bohendra Tiwari, the Minister of Planning published a request for proposals, inviting people to make proposals to design, finance, and construct projects on that land. And the JCC, at that time I was president, the JCC made immediate, very strong complaints. We were joined by other people. We were joined by the Chamber of Commerce, the Manufacturers Association, and the Transparency Institute. The JCC made complaints that, in fact, what was taking place there was improper, and it did not follow best practice. And that actually came to a much more forceful focus in December of 2011 when we pointed out to the minister in writing that what was taking place at Invaders Bay was a breach of the Central Tenders Board Act. So in fact it was illegal. Apart from it being something that we didn't agree with, it was illegal.
But the minister said that they were in conformity with this.
Well, this is where it gets interesting. The minister then said he was going to get legal opinions on the question we raised. So we have the issue of someone embarking on a major project without having legal advice on the legality of what they were doing. So that's the first thing we observed by the fact that he was only now going to get legal advice. He got the legal advice, this is Dr. Tiwari, and told the Parliament and the JCC that the legal advice he had was that he was in conformity with the law and he hadn't broken the law. To cut a long story short, we were very skeptical. We didn't believe him, and we said to him, right, well, give us the advice.
Let us see what you predicated your opinion on. Yes. Mm-hmm.
And in fact, it's ironic, and it's Sunday morning, so we can have a bit of fun. It's ironic that, in fact, when Dr. Tiwari spoke with the Senate on the 28th of February of 2012, and he was answering a question placed by Independent Senator Dr. James Armstrong, as he then was, Dr. Tiwari answered the question in the same sort of way that they were in conformity. And one of the PNM senators who was present asked him, why don't you give us a copy of the advice?
Yes.
And of course, that PNM senator is none other than the current Attorney General, Faris Al-Rawi. So in fact, at that time, as we like to say, at that time, Mr. Al-Rawi displayed a curiosity that was aligned with my own. What is the advice?
Everybody was in concert, yes.
Yes, everybody was in concert, but we got out of tune, you see. So what is happening here is that Dr. Tiwari refused to publish the advice, and that is what sparked the lawsuit. Because we applied under the Freedom of Information Act. We were refused. We applied for judicial review, which is a court process to review administrative decisions. And that is what led us to the victory in the High Court in July of 2014 and the victory in the Appeal Court at the end of October of 2016.
Let's make very clear, Afra Raymond is the voice you're hearing this morning. He's our guest, and we are talking about the Invaders Bay appeal that is now going before the Privy Council. What specific information you sought under the Freedom of Information Act? I know one part had to do with how much money was spent on legal fees. What else?
Well, what we sought actually, Rennie, was two things, to be very precise. We sought all of the letters of instruction, and we sought all of the legal advice. We didn't ask the fees. The question about the fees, Rennie, which is an important question, was always raised as a supplementary question.
Okay.
It was never part of the Freedom of Information situation.
Request.
And we were asking for the legal opinions and the instructions for those legal opinions. And for whatever reason, there's been an almighty fight, which continues to this day, for those things. And you see, what is really curious about it is this. What happens in this country, and we all know it, is that if a political person, a person in public office, is under challenge for a particular thing, a decision that they took, and they get legal opinions that support what they did, they publish them, or they cause them to be published.
But when you don't have justification or you cannot prove that, then we have a problem getting it.
But what is interesting is that in this case, we have a high public official doing something under heavy criticism. He gets a legal opinion that he said, in fact, he has several legal opinions that he said vindicate what he was doing,
yes.
And he wouldn't publish those. And this has to be the most mysterious thing. I mean, we are the 27th of November, and I think I could say, as a Trinidadian, that Christmas is ready for children.
Well, this is not just the only part. There are many mysterious parts of this. I want to kind of quantum leap just a little bit, because you took this to court, you won it, it was appealed, you got the appeal also.
Yes.
Now, here is where the curiosity comes, because you mentioned that the current AG, Francis Arawi, and the opposition then said, yes, JCC, yes, you are right. Yes, Afra, you are on the case. We should see this if, in fact, he got this legal opinion that keeps him in conformity with the tendering regulations. But suddenly they have changed. Why?
Well, let us take a pen and make a point here.
Go ahead.
I wouldn't know why, but I'll put a couple of things forward for consideration. The first thing is that we need to be quite clear that this case, the JCC versus the Ministry of Planning, and then the Ministry of Planning versus the JCC, this case is actually quite an historic one. And not in a tautological sense that every case is historic, but this is actually a landmark case.
Yes.
Because what is being weighed here is the ancient legal right of legal professional privilege, which means that anybody who gets the only person who can decide to publish that advice is the actual client. That is an ancient right that is pretty much international. Okay? The legal professional privilege is a very serious and ancient right, and it's one of the cornerstones of the legal system. And that as I said, ancient. And that is being balanced against the Freedom of Information Act, which is a modern conceptual framework. So, for example, in Trinidad and Tobago, our Freedom of Information Act is a 1999 act. In the UK, pardon me, which we often like to sort of aspire to as a status, in the UK, their Freedom of Information Act only came into power in 2000. So Trinidad and Tobago got a Freedom of Information Act in advance of the United Kingdom. So the point is that our Freedom of Information Act makes it possible, lawful for a citizen to apply and to get official documents unless, pardon me, one of the exemptions apply. So we actually have a contest here in between an ancient right and a modern right. Now, of course, the Freedom of Information Act, for the benefit of listeners, the Freedom of Information Act actually contains a section 35, that requires a public authority to whom the application has been made for the information to carry out a public interest test. The public interest test is an intentional process in the legislation, so that if a public authority receives an application for something, and if they decide that that something is exempt, there are 10 exemptions, sections 24 to 34. If they decide that something is exempt, they then have to apply a section 35 test. In other words, this is exempt, but how will its publication harm the public interest? And having carried out the section 35 test, they have to give their reasons in a notice to the applicant. All of this is to say that the Freedom of Information Act was actually constructed consciously, with a mind that it was going to be traversing previously existing rights.
And I think you just answered my question, though you said you couldn't say what was in their minds, but you just made it clear, because it now opens a whole different card game, as it were, dealing with information that should come to the public and who has the right to request or delay or deliver, rather, that information. Now I understand why we may be seeing a change in position, because it is not only going to apply to this Invaders Bay situation, but to many situations down the line.
Well, this is where it gets interesting, Rennie, because let's get a little more specific around the Invaders Bay scenario and the ruling. This scenario, we need to be quite clear. The Ministry of Planning did not follow the legal procedure set out in the Act. So the first thing they were supposed to do was to say what section were they claiming as an exemption. They started off claiming one section, and after our litigation started, they changed part of the way through. The second thing was that having chosen an exemption, you are actually supposed to carry out a Section 35 test, a public interest test. They never did a public interest test. Okay? And they never sent the required notice. So in fact, the Ministry of Planning, at a fundamental level, procedurally, how they handled the application, they were in breach of the law. Now, coming to the question you raised about a precedent. It's an important precedent, because what it does is it fortifies the case. Yeah, it fortifies the case that, in fact, the Section 35 test is of tremendous value and it is mandatory. So, in fact, it is not enough for public authority to declare, we're not giving you this because of that reason. You have to tell me you didn't want to give it to me because of this reason, and we carried out a public interest test, what it was. Because what is happening here is that in the judgments that were done by the three justices, and this is a very unusual appeal court situation, in that most times the appeal court will give a ruling. Occasionally, one of the judges may differ from their colleague, and that judge may write a dissenting ruling. So that person would give a minority report, as it were. This is the only case I've ever heard about where each of the three judges wrote their own judgment. So there was a lot of deep water to be understood, a lot of issues to be examined, and the three judges gave rulings. Even the one who didn't agree with JCC, which is Justice Rajendra Narayan, I found his ruling to be of immense interest.
You see, you also found it of interest that Justice Nolan Bureau ruling that this is more than just a issue of legality, but transparency.
Absolutely. So there was really some tremendous lessons imparted by the judges there. So the point I want to make, which I have not made in the column you're referring to, but I will make it in a column coming up. The point I want to make is that if you do a reading of those rulings, you would see that the judges actually go to pains. Barrow, Jamada, in Narayan not so much, but the judges go to pains to separate this case from becoming a general precedent. And without saying it, I mean, I am going to say it, but they didn't say it. Without saying it, what they're actually coming on is that in fact, they are they're coming on the fact that this case is one in which the particular facts of the case are such that the court could hardly find otherwise. And let us step back about 4 or 5 minutes in our discourse to put into focus what are the particular facts. And the particular facts are this. Forget the personalities. I mean, I have my difficulties with Minister Tiwari over several years. But forget the personalities. We have a public authority proposing to carry out a large-scale development on public land, which anywhere you take it will involve an investment of billions of dollars in either public cash or public land. Dr. Tiwari told us on the 1st of March 2012 that land, undeveloped land, had been valued for $1.28 billion. Heaven knows what its value is today. So that's the framework. When you get out to get your elbows into the thing and look at it, so we have this large-scale development on public land, supposedly in the public interest, at public expense. An independent group raises a very pointed criticism. Very pointed. It wasn't old talk. It was several pages long, very detailed about how what you are doing is in breach of the law. Exactly what sections of the law you broke. You tell us you're getting legal advice on it. And you come back and you tell us you've had legal advice from this person, that person, and the other person. And the legal advice explains that what you're doing is just fine. You're not breaking the law. It conforms to the law. And when we ask you for the legal advice, you won't publish it. And that matrix of circumstances is what the appeal court was ruling on. That is what Justice Frank C. Prasad was ruling on. Because the point being, let's just work back the algebra snappy now for the students in class. The point being, if you're doing a public interest test, and one of the key measures in the public interest test is whether the publication of this document will harm the public interest, or will harm the interest of the state, or will harm the interest of the ministry, or will it enhance the public interest in terms of the right to know being an interest of paramount importance. The question has to be, if that opinion was an opinion that supported what the ministry was doing, how can there possibly be any public harm in publishing it? That's what Justice C. Prasad was saying without saying. And that's what the 2 out of the 3 judges in the appeal court were saying without saying. And I'm confident, I'll say it now, I'm confident that if this matter goes to the Privy Council, I hope it doesn't, but if this matter goes to the Privy Council, I'm confident that good sense would also prevail swiftly, and this thing could be put in the correct order. We need to get all the instructions published. We need to get all of the legal opinions published. That is our land. That land doesn't belong to any political administration. That is our land. And all of y'all, whether it is the PNM cabinet at present or the People's Partnership cabinet in recent past, all of y'all are public servants. Y'all are working for us. You are our staff, and we're asking to see what's in that file. So bring this matter to order and publish the information.
It is going to be a ruling that will affect a number of other things.
Absolutely.
When you talk about requests for proposals, when we talk about process to ensure that you are compliant, it means that if you get advice to tell you that you are, we need to see it, is what you are contending.
Yes.
That we have not seen, and the understanding as to why the then opposition, now the governing body, may have a problem with this, which is clearly because it is being taken to the Privy Council, is because of the transparency involved. So it is more than an Invaders Bay issue now. It is a case of accountability and transparency.
Absolutely.
Afra, as always, man, you've taken up your time, you've taken up your resources, you have taken not only in this area, but the same thing with Clico, this Invaders Bay situation. Just in conclusion, my question to you is, this Privy Council appeal, taking this to the Privy Council, you said that you're hoping for a speedy solution. Is that the history of the Privy Council?
Okay, let me just answer that very swiftly. Some people have commented on the book and elsewhere that in fact the Privy Council thing is going to take years and so on. I don't know how long it will take them to get the matter listed. I don't know how long it will take them to get the matter listed. I'm not trained in those things, but I can say that from my readings, the Privy Council does appear, particularly where cases are straightforward, and this is pretty straightforward. The Privy Council does appear to be minded to give swift judgments. Sometimes they will tell you, wait right there, and they give it to you the same afternoon.
I like your optimism on this one.
Yeah, it
is necessary for a speedy ruling here, because in the area of cutting out waste, corruption, and so on, it is imperative that this be totally clear, and the accountability that is being sought here is made available to the public. It is not a case of who is in government. It is, in fact, the governed asking that the governors account to them.
Yes, and I want to say that it's a pity that I could sit here this morning, I think it's the 27th of November, I could sit here this morning and say that since the 28th of October, which is roughly a month since the appeal court ruled, I am the only voice that's been calling for those legal opinions and instructions to be published.
You are not
my erstwhile colleagues at the JCC appear to have lost their voices. I hope you're listening, all of you. The erstwhile colleagues appear to have lost their voices. The call for the information appears to have faded, maybe from memory or from priority, certainly from your agenda. But this is an important question of public interest, and if the JCC has lost its voice on speaking to the country's development agenda at a time when it's headed by a development planner, which is Dr. Jim Armstrong, what are we doing? Where is the national agenda in this? Is everything just about personal rights and personal advantage and who get what and so on? Where's the development agenda in the country?
Where is the country's interest?
Where are we going?
The country first?
And groups like that have a particular responsibility to conduct themselves in a certain sort of way. So it's disappointing, guys. You can still find your voices. You can come on the radio today. You can come on next week, and you can actually make a strong call. Forget about the Privy Council. Make a strong call for the information to be published, and join me in this call and continue with your work in the past. It's still possible to find yourself, yeah?
By supporting you in that appeal to restore voices, since both of us are challenged this morning, I'll leave the microphone open should they decide they can come here.
Sure. Sure.
After Raymond, I thank you so very much, my brother, for coming. I know that you're challenged with that cough. I'm having the same thing.
Yes.
But you held out pretty good. I'm hoping I can hold out pretty good for the next hour and 15 minutes myself.
Thank you.
My brother, good to see you.
Thank you.
And you have yourself a wonderful day.
Thanks for having me on.
It is.
Thanks very much, Rennie.
You're more than welcome, my brother.
Good one. Thank you.
Let's go. Right microphone. There you go. Afra, Raymond, take care, my brother. Have yourself a nice day. Managing Director of Raymond and Pay. Oh, by the way, Afra's website is something you can go to. Can you grab him the microphone? Just let me get his website so folks can get up there. Go ahead, Afra.
AfraRaymond.net contains all of the work, the TV shows, radio shows, and articles. And I thank you for your support, Rennie, and listeners. Thank you. Have a good day.
You have a good day, my brother. Thank you so very much.